Hello everyone, my name is Pravez Ahmad. I am a student of LL.M final year at Central University of Punjab, Bathinda. Today we are going to discuss about the writs in our constitution as a part of our legal awareness program. The Constitution of India is a fundamental law of nation which lays down rules and regulations to safeguard the rights of people and impose obligations on them. This set of basic principle is considered as the protection and custodian of the fundamental rights guaranteed to the people. One such right available to the individuals is the right of writs. The constitutional provision of India are authorized by the law. Therefore, the judiciary has independent jurisdiction to issue writs in the required matters. The conception of the writs is allowed. The conception of the writs is to allow instant determination of the rights of persons and to help the individuals that realize the benefit of this right. Under Article 32, Subclause 1 and Article 226, Subclause 2 of the Indian Constitution provides the Supreme Court and the High Court with two separate permanent provisions of the writ jurisdiction. The Supreme Court by virtue of Article 32 and the High Court by virtue of Article 226 are empowered to issue such writs. Although, according to the Article 22, the Supreme Court issues writs when the fundamental rights of an individual are infringed, while according to the Article 226, the High Court has a broader jurisdiction to issue a writ for violation of both legal as well as the fundamental rights. Now we will discuss the types of writs which are given in our constitution. The Supreme Court of India the Supreme Court of India is defender of the fundamental rights of the citizens. For that, it has original and void power. It issues five kind of writs for the enforcing the fundamental rights of the citizens. The five types of writs are as first the habeas corpus, which we are going to discuss in detail later. The second is mandamus, prohibitio, certiorari, and quo warranto. In this video, I will discuss habeas corpus as a part of my legal awareness program. Meaning of the writ habeas corpus. Habeas corpus is the most valuable writ as it determines the right to freedom and personal liberty. It is derived from a Latin word term meaning have a body. After an individual is detained, he can appeal to the court for the issue of habeas corpus. The order from the court to determining authority to produce the detained individual before it is to examine whether the person has been detained legally or not. If the court is certain that the individual is unlawfully detained, it can be issued order for his release. The principle of the writ of habeas corpus assures that a prisoner can be released from illegal detention, that's detention without sufficient evidence or cause. Now, who can apply for the writ of habeas corpus? Prerequisites for the application of the writ habeas corpus. The person who is unlawfully detained. Second, the person who is acquainted with the benefits of the case. The person who understands the facts and the conditions of the case and voluntarily files for the application of the writ of habeas corpus under Article 32 and 226 of the Constitution of India. The general rule is that the filing of writ of habeas corpus can be done by an individual who is unlawfully detained. However, in some cases, an individual may petition in the court or judge for the application of the writ on behalf of the distance, that's family members or friends. One reason someone other that the petition is filing for the writ is that the person detained might be held incommunicado. When is the writ of habeas corpus refused? In the following situations, the writ of habeas corpus will be refused by the court: where the court has no territorial jurisdiction over the detainer, where the detention of an individual is related to a court order, where the detainee is already released, where the detention of person has been legalized by the removal of defect, and the last one is where the competent court rejects the petition based on the merits of the case. Now, whether the doctrine of res judicata applicable to the writ of habeas corpus. When it comes to the unlawful detention of an individual, the doctrine of res judicata does not apply in accordance with the Article 32 of Article 32. Consecutive petition for the writ of habeas corpus can be brought before the court or a new ground which were not covered in the earlier petition filed for the same. If the petition for habeas corpus is filed in a form with the independent evidence, independent jurisdiction and authority, it can be upheld. I hope this video has helped you in grasping the rights provided to all of us under the writs of our constitution, and provide you a better understanding. Thank you.